Morning. I first of all want to thank all of the organizers for putting together this program. I think it's really important that we start to talk about these issues and talk about these issues in a positive way of sort of a free dialogue of how to move forward, and really the whole topic of the discussion, Casus Beli, or is it going to lead to peace? I think that there really is the potential for bringing all the actors in this area, and Daniel gave a whole map of all of the actors in the area of bringing them closer together for the benefit of all peoples in this area. And so I am the Deputy Director of the International Law Department at the Foreign Ministry. Some of my portfolios include maritime law and the Division of Shared Natural Resources. I'm working right now, worked on the delimitation agreement with Cyprus. Now in the middle of negotiations with our Cypriot friends on unitization, and we'll get to that a little bit. I want to talk about legal issues that arise due to the discovery of gas, of hydrocarbons in the Mediterranean. Like the introduction said, years ago they really didn't think there was much out there, and sort of with the discovery of gas and the potential, there's been a lot of legal issues that have arisen. Now, in the first lecture, and some of my lectures sort of overlaps, and I'll go through it quickly, going to talk a little bit about border issues from the Israeli perspective, and looking at those issues. And I want to comment on a couple of things that were raised in the first set of comments. And then I want to talk about also the question of what happens if we discover gas and it's a reservoir that goes cross-boundary. What are the legal mechanisms for division of the gas? How can we cooperate on those issues? Because that, again, could be potential for disputes, or it could be a potential for a great deal of cooperation. So, let's see. No? There we go. Okay, I want to just give you a sense, because I know not all of us are maritime lawyers, of the different areas that we're talking about when we talk about the exclusive economic zone, we talk about the continental shelf, a quick run through of all the different areas. So you have the land, and then you have, under the UN Convention of the Law of the Sea, various different maritime zones. Now I want to be clear, the issue was raised. It is true, Israel is not a party to the UN Convention of the Law of the Sea. That said, like it was said in the introduction, most serious legal scholars would view the UN Convention of the Law of the Sea as customary and as binding, and Israel too views the UN Convention of the Law of the Sea as largely customary and binding. Certainly all the provisions that relate to the topics that we are going to discuss today, Israel sees itself as bound by, since the UN Convention of the Law of the Sea is customary in those provisions. And so Israel has an obligation and does act in accordance with those provisions, and those were the provisions that really guided us in our negotiations with Cyprus and continue to guide us today. So under the UN Convention of the Law of the Sea, you have various maritime zones, the first being the territorial sea, and that's where a country 12 nautical miles from the coast exercises full sovereignty. The law of Tel Aviv would be the law of the territorial sea. Then you have an additional area where the contiguous zone, we won't get into that, but the country could exercise limited sovereignty in that additional 12 nautical mile zone. And then really what we're talking about is both the continental shelf, that is to say the land, the seabed, the floor of the sea, and that goes out. And we're talking about the eastern basin of the Mediterranean, we're talking about up to a limit of 200 nautical miles, but like was said, there is an overlap. You never have 200 nautical miles. And the exclusive economic zone, which correctly it was said that it's not an area where the country exercises full sovereignty, with the exception of if you build artificial islands or installations in those areas, but it's areas where, like the name implies, country exercises exclusive rights in the realm of economics and research rights. And interestingly, under the UN Convention of the Law of the Sea, anything that comes off the continental shelf, a country has exclusive rights to that, whether or not it takes any sort of positive act in claiming those rights. That's Article 77.3, that you would have automatic, without any sort of positive act, claiming those rights. So we've already talked a little bit about the UN Convention of the Law of the Sea. There are two separate provisions of how do we go about the limitation issues when we're talking about territorial sea, again, that first 12 nautical mile area. And there the focus is on focusing on the issue of equidistance. That is to say, there is a mathematical approach. Of course, There is not. Just read an article. It said there's an exact definition because this is a mathematical approach, but that wouldn't be true. Obviously, they're subject for interpretation. Around the world, we find maritime disputes disputing what the exact mathematical approach should be taken when we're approaching equidistance. And then we have the provision that Daniel showed us about the division of the exclusive economic zone. There's more of an emphasis, if you look at the first provision, on getting to an equitable solution. But if you take a look at case law, generally speaking, be it the Permanent Court of Arbitration or the ICJ, if they're dealing with a maritime dispute, their default will be to look at the more mathematical solution of how to divide it up, that is to say, to get to an equidistance line. And then they'll look at if there are any special circumstances to be taken into account. Were there any historical agreements that should influence it? Was there tacit approval of a certain situation? Are there unique geographical conditions that should influence the outcome? There's no closed list, by the way, of what special circumstances are. In the context of gas, actually, it's been said that actions of countries taken in the context of gas shouldn't influence the line unless there's explicit or tacit approval to the arrangements. That is to say, if one country is acting and exercising economic rights and the other country sits aside and accepts that, or explicitly accepts that, then that might influence the final outcome. There's also issues of proportionality, and here we're not talking about if there's a 3-to-1 proportionality issue, but if it's really like a gross proportionality issue, that might also influence equitable solution. Now I want to talk a little bit about our region specifically. In the past almost 10 years, there's been a lot of movement, certainly because Cyprus is at the center of the eastern basin of the Mediterranean, and there are, as was discussed, overlapping claims of exclusive economic zones. The ideal solution is to reach formal agreements, and Cyprus has been quite active in entering into these formal agreements with its neighbors. The first such agreement, which is a formal agreement in full force, deposited in the UN, is between Egypt and Cyprus. That was negotiated in 2003, entry into force in 2004. Now, in 2007, and we'll talk about this a little bit later with maps, Cyprus and Lebanon entered into a similar agreement for the division, again, of the overlapping claims, because again, we don't have 400 nautical miles in the exclusive economic zone. And it is true that Lebanon has yet to ratify it. However, it should be noted that this agreement was signed. And usually in terms of treaty law, once countries sign it, at least on the bilateral level, it is supposed to bind countries to act in accordance to what was agreed in a signed bilateral agreement. In every country, Israel, Cyprus, and others, the ratification process can sometimes take a long time. Sometimes you have to get, in Israel, you have to get your domestic legislation in line. But already, once we do the formal signing process, we're bound to act in accordance. Now, in summer 2010, following the Egyptian and Lebanese models, we too entered into negotiations with Cyprus. The issue here is very simple. Investors wanted to come, discovery of large amounts of gas. The technical experts can go into the exact figures. But we'd get calls, and I can say just anecdotally, I'd get calls, well, can you give me an informal map where the exact coordinates are? Because no investor wants to go and invest loads of money wherever every meter counts. They want to know exactly where the coordinates are that divide up, where is Cyprus and where is Israel? And even countries with very good relations, it's very important that we be clear where we are and where our neighbors are. Now, in December 2010, again, involved in these negotiations, we signed our agreement with Cyprus, and both sides ratified, and it entered into force. The agreement, like the Egyptian agreement, was deposited with the UN, and you can find it on the internet. Now, also in 2010, Lebanon did an interesting thing, and I'm going to show you on a map what it did. As we discussed, Lebanon and Cyprus had an agreement in 2007. Lebanon then decided to go ahead and do two unilateral moves. Now, as was discussed in the previous presentation, what's required under customary international law is that countries have a discussion with one another. The countries try to enter, ideally, into a formal agreement, but if they can't enter into a formal agreement, the next best would be to enter into provisional arrangements. Lebanon went ahead and, contrary to international law requirements, deposited 2 deposits. The first was that it set unilaterally its own maritime delimitation between Lebanon and Israel, starting in the territorial sea and moving out westward towards the exclusive economic zone. The other move that Lebanon did was that it unilaterally amended, and I'll put that in quotation marks because they never ratified their agreement with Cyprus, and drew their exclusive economic zone agreement with Cyprus, pulled it down southwards. And we're going to take a look. Now, I just want to say that Israel, again, we talked about what influences border agreements if you would go to an international court of law, if you were to go to arbitration. And again, they start with the mathematical solution. Always the court will look at trying and bring in experts and cartographers and get to mathematical solutions. But then they'll also look at what I discussed as special circumstances. Now, as I said, one of these special circumstances is the question of, is there tacit agreement to a certain situation? Now, Israel and our experts, our cartographic experts, legal experts, analyzing the Lebanese move, again, contradicts its initial position in 2007. And you have to remember that having been involved in these negotiations, it's not like you sit down and just draw a line on a map. I mean, these are intense conversations where even positive negotiations between friendly states, everyone is arguing about every meter and which way the line should go. 2007, Lebanese experts got to a certain result, and very curiously, after the discovery of gas, decided to pull the line southwards. Now, Israel disagrees with Lebanese position from a professional point of view, from a cartographic point of view, from a legal point of view. And in order to avoid this tacit acquiescence to the situation, Israel was forced in 2011 to submit its position on where the maritime border lies. And again, this is to avoid a situation of tacit acquiescence, of acceptance of a Lebanese border that we don't agree with legally and professionally. You just saw the map from our agreement. We actually superimposed, with the help of our cartographer, our agreement as opposed to the agreement with Egypt and the agreement with Lebanon in 2007. So as you can see, we accepted point 12, which is the final point between Cyprus and Egypt. That is to say, there's no contradiction between our EEZ agreement with Cyprus and Egypt's EEZ agreement with Cyprus. They mesh, they agree with one another. And also, at point 1, which is the northmost point in our agreement, Israel's agreement with Cyprus, and Lebanon's southmost point under the 2007 agreement. So that's sort of a superimposition of our map. We all used a British chart to map this out. And there's just we saw that in the last presentation. Now, I want to just show you a little bit about the disputed area. And this is obviously a schematic map, and you shouldn't, not everything's a perfectly straight line, but it gives us a sense. So here you have the agreed Israel-Cypriot border in orange, between points 12, the last point on the Egypt-Cypriot agreement, and point 1, the last point on the Lebanese Cypriot agreement from 2007. And there you have Lebanon. And Lebanon went ahead, again, like we said, in 2010, 2 unilateral deposits, one creating this line here, its unilateral position on where the sea border should be with Israel, and here, a little bit of pulling down the line from 2007, again, unilaterally amending their agreement with Lebanon. I want to just mention the fact that if you take a look at this blue line right here, may have seen reports in Lebanese newspapers, you know, that Leviathan and Tamar, the discoveries of Israeli gas, very major discoveries of Israeli gas in the Mediterranean, somehow enter into the Lebanese area. Well, even if you go according to the Lebanese position on where the maritime border should be, you see that Leviathan and Tamar, some 40 kilometers from those areas, self-contained reservoirs, that all the information on them is public, you know, all these companies are publicly traded, they have to produce it, are nowhere near the Lebanese area. Now, then you have, in 2011, Israel, again, submitting to the United Nations its position on where the maritime border should be. I want to emphasize that in our submission to the UN, we emphasize two things. First of all, Daniel mentioned the fact that we have a provision in our EEZ agreement. 2 minutes? Can I have 3? Our EEZ agreement, we have a provision that allows for all 3 parties involved to amend the tri-points, and that's an important provision. We also mirrored the language of the UN Convention on the Law of the Sea. Israel's very strong message is that we are very open to dialogue with our neighbors. The problem is that our neighbor Lebanon, even in its submission to the UN, couldn't even use, Daniel mentioned that he was surprised that they couldn't even say the word Israel in its submission. I will also note that 2 of the agreements that Daniel talked about that were referenced in the Lebanese position, actually, they're very problematic. It's true that the land influences the sea, and you do look at historic agreements. But actually, in the 1923, the Palais-Nukom agreement, the land border never ever reaches the sea. You don't have, the land border is actually several meters away from the sea, so you don't have any sort of historic agreement that talks about sea issues. Another thing they reference is the 1949 Armistice Agreement. I challenge any of you to come up with an agreed signed map between Lebanon and Israel on that issue. That is actually something that's, there is no map of the Israel-Lebanon Armistice Agreement, so it's a sort of creative thing. Now, just in the last 2 minutes, I'll talk a little bit about the second issue I want to talk about. What happens if there's a transboundary reservoir? What happens? Now, we already know about one. There's Aphrodite, Block 12. And indeed, in our exclusive economic delimitation agreement, we actually agreed, and the Cypriots agreed, to negotiate something known as, we have a legal tool known as unitization. And what that means in layman's terms is that a single unit operator will develop a cross-boundary reservoir in order to maximize the profits. Actually, I want to just show you sort of here. I also want to be clear that that is not the, potentially there could be other reservoir. So wait, let's go back. So I want to show you, this is a picture of a pie, and I want to explain to you that a transboundary reservoir is not like a pie that you can say, I have 70%, you have 30%, and let's just divide it up so you can start developing, and we'll leave the 30% to us. First of all, technologically, as you develop the transboundary reservoir, you actually get a better and better picture of what's there. So you might start out with a 30-70 divide and then realize you're going to adjust it to 40-60. And so it's very important, in order to maximize profits, to do unitization. Unitization is not customary. It's not something that's binding in international law, but actually the International Law Commission talked about this as being something that is a developing international practice, and it's what's done with many countries. It's much more like, I want to say, not like a pie, but like drinking out of the same cup. And so you can't have one person start drinking and thinking they're going to get their 70%. So unitization, we have some classic models, particularly the sort of best ones perhaps are between Norway and Britain. We could discuss, and if we want to discuss afterwards, these are very complex agreements because they have so many layers of cooperation. You have government level, since the framework. You have private actors that need to enter into their own private agreements. And you have other issues involved in unitization, perhaps different fiscal system, different import-export policies, different interests. You rarely have the 50-50 division. Sometimes it's a 40-60 division. Sometimes it's even greater, 90-10. And these differences of interests, and we won't go into that. Now, what happens if you don't have a border? Can you develop cross-boundary reservoirs? And in our situation, we don't have borders with everybody. The answer is a resounding yes. You have models. Some are very robust models, like East Timor and Australia, Malaysia and Thailand. Some are less robust models of situations where you don't have an agreed border, and yet there is transboundary development. Again, another legal tool that could definitely lead to greater peace and greater cooperation, even when you don't have an agreed border. And it's a very important thing to bring up, certainly in the context of the Eastern Basin of the Middle East. We'll skip this slide, because we don't have so much time. So, today's discussion is, will the discovery of Mediterranean lead to peace, to war? The answer is all of the above. And really, the question is really an issue of if the actors are going to act rationally, and that is really, Israel wants to act rationally. It started out the process of doing the right thing, of entering into a formal agreement with Cyprus. We want to work in cooperation with our neighbors to the development of all. We certainly we sent a message even when we deposited our reaction to the Lebanese unilateral position that we are open to dialogue. We are open to, so long as it's a serious, not political dialogue, a serious cartographic dialogue, a serious legal dialogue of how we both benefit, a win-win situation instead of lose-lose. And that's that. So I thank you very much, and sorry I went a little